Welcome back to Rationally Based, a podcast about law and politics on the edge. Kathryn, what's on deck for today?
Well, today there's a lot to cover. We're going to talk about updates on Don Lemon. Is he really a journalist? And is he protected by the First Amendment? Did Lemon actually violate the FACE Act? And is Lemon willing to sacrifice the New Deal to save himself? Then a lawsuit filed in Missouri over the census, including who counts for purposes of apportionment. But first, there was some breaking news that we'll hit on quickly. A judge ordered the continuation of temporary protective status for people from Haiti.
Let's dive in.
Welcome back. I'm your host, Ilan Wurman, a law professor at the University of Minnesota Law School.
I'm Grace Keating with Center of the American Experiment.
And I'm Kathryn Johnson, also with Center of the American Experiment.
So where should we start today?
Before we get to the meat of today's episode, we just want to take a moment and thank everyone who listened to episode 1 of Rationally Based and who came back for more. We are so excited about this show, and it seems like you guys are really liking it so far. We were getting tons of good feedback from you. If you enjoyed the first episode, if you enjoyed this episode, just give us a little support, drop a like, drop a comment, share it with a friend, because when starting a new show, you know, the early feedback and the early support is so critical. So thank you so much for going along with us on this fun ride.
And speaking of reaching out, a few of you reached out to us about the Brady handgun bill that we discussed last week. I believe we have a clarification.
Yes. So as I was riffing on the Brady handgun bill, I said I think the bill was named after Ronald Reagan's Secret Service agent who died in the assassination attempt. But thank you for correcting the record. Us youngins don't exactly remember that episode. I think we were all born after it. But Mr. Brady, Mr. James Brady, was actually Ronald Reagan's press secretary who was grievously wounded, shot in the head during the episode, and he survived and became a champion of the bill that became the Brady handgun bill. So thank you for correcting the record, and we certainly want to pay our due respect to Mr. Brady.
And yeah, feel free to correct us all you want, especially Ilan. If he gets anything wrong, feel free to correct him in the comments.
For the record, I will rarely be wrong, but if you insist on correcting me, you may make the attempt in the comments. We certainly appreciate the dialogue.
Love the humility.
Let's start with that breaking news. This just happened, yesterday, over the weekend. Federal judge Ana Reyes blocked the Trump administration from ending the temporary protected status of more than 350,000 Haitian immigrants. Tell us more about that, Ilan.
So it was set to expire. This is a temporary protected status is in the statute, and it's supposed to last for 18 months after there's a designation, but the administration can continue it or it can let it expire, and it was due to expire, and the administration wanted to let it expire, but the judge here said that they did not follow the correct process for terminating temporary protected status. The legal question that's most interesting to me, probably boring, is the administrative process question. Is there actually jurisdiction in the district courts over this? So the statute actually says district courts do not have jurisdiction to review determinations about temporary protected status, whether to continue it or not. So how did Judge Reyes have jurisdiction to decide this? Well, she distinguished between reviewing the process leading up to the determination and whether the statutory process was followed and the determination itself. As far as I know, that distinction has never been made before. She does cite 2 cases, but they really stand for a slightly different proposition. So I would not be surprised if the D.C. Circuit or the Supreme Court reversed it or at least stayed the decision and pretty quickly.
Yeah, so what happens now? Does it get appealed and maybe the status will expire?
So they could appeal the determination on an emergency basis, for example, in the D.C. Circuit. They could file a petition for a stay. And then the question is the likelihood of success on the merits. And my guess is the D.C. Circuit will say they have a likelihood of succeeding on this jurisdictional claim. On the substantive merits of temporary protected status is a separate sort of interesting question, right? I mean, it's been, I think the temporary protected status for Haiti emerged in 2010 after a major earthquake. And it's obviously been a long time since then. So raising some interesting questions of how temporary protected status really is supposed to be.
Right. That's not super temporary. And also it's set to expire. I understand there's a process that goes along with making sure it expires, but it's interesting that you just can't let it expire.
Yeah, it depends on what the statute says. And again, I've not read this provision of the statute. I just read the judge's opinion this morning. This came in last night. And she says that the statute says that the temporary protected status shall be extended by default under the statute unless a determination is made to let it expire. And so the administration made that determination, which again is not reviewable under the statute. But she said that the process that they followed was inconsistent with the statutory process that was required. And so they did not take the proper steps to let it expire. So I guess the default is it doesn't expire, it continues, which is kind of an interesting default mechanism.
That's crazy. It seems to go against the intent of what a temporary protected status should mean for people coming from countries in crisis, basically. I mean, if this is stemming from temporary, yeah, if this is stemming from something that happened back in 2010, we're in 2026 talking about whether or not we should let it expire. I mean, that just seems crazy to me.
Yeah, I mean, there was the earthquake at first, right? And then there was a hurricane, and then there's just kind of like internal civil strife and civil war. I don't even know if they have like a really functional government right now. But there's certainly a case to be made that this isn't to diminish the plight of people who live in Haiti, but that kind of describes many countries, right, in the world. Like,
right.
It turns out that having functional civil society, functioning democratic government is something that is an aberration in human history. And I mean, if you look at 3,000 years of human history, this project in functional civil society, liberal democracy, it's only existed in a small span of the globe in a small sliver of time. And if that's the reason to grant temporary protected status to Haiti, then it sounds like you should be able to grant that to lots of countries, which would be quite unusual and probably contrary to the intent of the statute.
Right. We can't just bring in anyone whose country is dysfunctional, especially when right now we have 1.3 million people with that temporary protected status in America. So my question for later, which I don't know, do we know the answer to this? Are those people counted in the census?
Oh, we will talk about the census. I think under the present rules, they are counted. I mean, if you've been here for 15 years and it's their place of abode, their usual place where they sleep, they're not sleeping in Haiti, and they certainly don't intend to go back.
Even though it's temporary.
Even though it's temporary.
It's in the word, we're saying.
I think the census litigation that we're going to talk about later in the show is challenging their inclusion, like the inclusion of individuals like that and people on student visas or work visas. So we're excited to get to that topic. So stay tuned for that.
Well, that was not our only piece of breaking news this week. As many of you probably saw, Don Lemon was arrested for his role in the city's church protest in St. Paul. We covered this pretty heavily on last week's episode, but I think that we'll roll that clip one more time just to remind you the environment that we're talking about when discussing his arrest, because this arrest has really ruffled some feathers. I'm hearing it from all people in my life who say, isn't he a journalist? How can you arrest a journalist? First Amendment, guys. We'll get into it, but let's roll this tape. This is while they were worshiping. I mean, interrupting a service.
Where are you?
Startles me every time.
Yeah. Where are your people? Why are you not at
So that's somebody screaming at the pastor, or
standing for our people? Where are you? You drink your coffee, you got your jewelry, you have your nice clothes, but what do you do?
I think we get the point of what's happening here. So last that we reported on the show, the New York Times had reported that DOJ was dropping this matter. Was that just a big psych?
It seems like it. I don't know if they were just playing their cards close to their chest or something, but no, they did move forward, and Don Lemon was arrested just a few days ago, much to the chagrin of many liberals across America.
Yeah, and the magistrate judge refused the warrant, right?
That was the big scandal or drama. Maybe not a scandal, but the big drama of the previous week was the magistrate judge had refused the warrant. So
the DOJ rushed an appeal to the 8th Circuit, which led the district judge who supervises the magistrate judge to send a letter to the court. And last we had heard, as of our last show, was that the DOJ had dropped the case. That was a psych. Okay. Now what has happened?
Well, they sent the case to a grand jury, which is what was surprising because we were worried that there wouldn't, what grand jury would file an indictment of this kind. But apparently they did find a grand jury to issue the indictment. And so grand juries, you can actually bypass magistrate judges for grand juries.
And the grand jury, my understanding, that's a group of people, much like a normal jury, right, versus a judge. So they found people in Minnesota even. Is that correct?
Yeah, a grand jury is drawn from the district in which the crimes that are being investigated are, right? So it has to, it's just like we say a jury of the veneer, a jury of the neighborhood where a crime is committed. This is at trial, you have a trial jury. This is actually called a petite jury, and then you have the
I'm sorry, what?
okay,
There's a petite?
a petite jury as opposed to a grand versus petite.
I have never heard that in my entire life.
Didn't you take French in like high school or something?
I know it means small. I can give you that, but I didn't realize it could apply to juries.
What's a petite jury?
Is it just a smaller jury? That's what I'm getting.
Yeah, it's a trial jury. It's a petite jury is a small jury, a trial jury. A grand jury is the grander, larger jury.
I only ever hear about grand juries.
Yeah.
Now, of course, the question is, why do we even have French words in English legal system?
This is America.
Yeah, I think I'm more familiar. I'm more used to hearing like Latin in the legal system. Habeas corpus, that's Latin, isn't it?
Yes, it's anglicized Latin. That's right. But it turns out it has to do with the Norman Conquest of 1066.
Duh.
Sure.
King William defeating King Harold and the Normans, who are French, taking over England basically in 1066. 1066 and all
this
that.
affects us how?
Well, they brought their judicial and administrative processes, and the jury, although there probably were elements of juries in the Anglo-Saxon tradition, they really sort of crystallized into this, a 12-person jury, this petite jury, and a grand jury under the Norman administration in like the 12th century. We think is what the latest research shows about this. So that's actually what's called petite versus grand, But anyway, so that's why we have French, in case you were wondering, and in case you thought you weren't going to learn interesting things on this podcast. That's why there is French. Now, a grand jury doesn't actually adjudicate the facts of a case, right? That's what the petite jury is. That's what the trial jury is. The grand jury is usually, I think, 16 to 23 people, and grand juries are required to initiate prosecutions for capital cases or infamous crimes, which are just felonies for like a year or more in jail. The Fifth Amendment actually says this. Everyone thinks the Fifth Amendment, that's just the due process clause. Like the due process clause is there, but it says, I think something like no person shall be brought to answer for a capital or otherwise infamous crime except on a presentment or indictment by a grand jury. So it's this shield between, the people are a shield between the government and these criminal defendants to ensure before you can initiate a prosecution that could end in someone's life ending or imprisonment for a long period of time, you need a body of citizens, the grand jury, to decide that there's sufficient evidence to bring it forward. So those are required actually for felony cases and capital cases under the Fifth Amendment, but you could always use them in lesser offenses as well to get around judges who refuse to issue warrants. So that's, I guess, how they got around the magistrate judge's refusal in this case.
That is fascinating. So anytime I'm watching like 12 Angry Men, that's a petite jury.
That's a petite jury.
Not a grand jury.
Yes, that's a petite jury. 12 Angry Men, Kathryn, you've got to watch
show?
this. It is one of, Henry Fonda.
It's a movie.
Henry Fonda.
I've never seen any
watch
movies.
Yeah,
I don't watch movies. I'm sorry.
What's the movie that everybody watches with Tom Cruise and,
A Few Good Men.
A Few Good Men. Okay, Code Red. Okay, that's
Great movie.
Great movie. But 12 Angry Men. Oh man,
it is really worth watching.
You must watch.
Just like a couple hours of your life. It's great. Great
I
acting.
will fall asleep. The reason I don't watch movies is because I'll fall asleep. Okay, so I'll try for you guys.
Back to the issue at hand. Don Lemon's lawyer came out with a statement after this arrest saying that the charge was, quote, an unprecedented attack on the First Amendment and transparent attempt to distract attention from the many crises facing this administration. So the thing I keep hearing again and again from people is Don Lemon, as a journalist, in quotes, journalist, protected by the First Amendment, or isn't he?
With his YouTube show, to be clear.
He's
has a
not
YouTube
with
show.
CNN anymore. This is just sort of like, he's like an independent journalist, I suppose.
Right, just like radically based.
Just
Rationally based. We are radical. We are absolutely radical. We are radical, but we're also rational. And so,
say radically based.
We'll get a t-shirt that
So
says
subconscious.
radically based and crossed out rationally based.
just to be clear, Kathryn is the most radical among us. So we have to rein her in regularly as we prepare for this show. But yes, we, I think, would be journalists of the kind that Don Lemon is. And the question is, do us journalists, Don Lemon, rationally based, the New York Times, as institutional journalists have special protections under the First Amendment, which guarantees the freedom of the press? And the answer actually is no. So the debate is, does it protect institutional press? Is that what the freedom is? The freedom to be an investigative journalist and to go to events, is it a freedom to break into someone's home to report on what's going on there or to keep your sources confidential? Or is it the right of every person to enjoy the freedom of the printing press, the technology available to publish your thoughts? So the freedom of speech is the freedom to speak, but the freedom of the press is the freedom of every person to publish their sentiments. So there's a seminal article on this by Eugene Volokh, who taught for many years at UCLA Law School, that basically address this question. Is it this institutional press protection, or is it a protection for every person to publish their sentiments? And I think, it's still the seminal paper. Many people have tried to attack it. I think those attacks have been unsuccessful. Some of the attacks have actually been quite vicious, which I don't quite understand academia, but one day maybe we will talk about why academics are so vicious.
That'd be a good topic.
About these issues. But I think Professor Volokh, or Eugene Volok's article, has withstood the test of time. And I brought just one example of evidence from Blackstone, just because we love Blackstone on this show. William Blackstone, of course, wrote the influential commentaries on the laws of England, highly influential in America at the founding. He describes the freedom of the press as follow. Every free man, right? Not just the New York Times. Every free man has an undoubted right to lay what sentiments he pleases before the public. To forbid this is to destroy the freedom of the press. So it's the right of every person. So was Don Lemon exercising freedom of the press? Yes, by publishing a video. That is the freedom of the press, but nobody is prosecuting him for publishing that video.
Right.
Which is more than you can say for an organization called Citizens United, which was prosecuted for publishing a video about Hillary Clinton. Do you even know what I'm talking about?
Yeah.
When I
so
say Citizens United?
I've heard the name. That's all I got.
It was like a huge deal and then kind of fizzled out. And now I think there's a lot of discussion over whether, it did a lot of negative things for campaign finance, didn't it?
Yeah, that's what the boomers really cared about this issue. Like they said, oh, this is evil corporate speech. So it was this decision that everyone interprets as like allowing corporations to exercise First Amendment rights.
What decade is this? Help me.
Oh, Grace.
Roughly. I'm sorry.
Well, the way you remember this is that famous or infamous, I should say, State of the Union, where President Obama, the Supreme Court had just decided this case. It was 2010.
Okay.
And
okay. Contextualizing.
So I think it was
she
the
was
20.
9.
I was a child.
You were alive though, right?
I was alive.
Yeah. Okay. So I think they decided the case in 2010. So it was either the 2010 State of the Union, or maybe it was the 2011 State of the Union. And President Obama, I think the decision was issued like just a week before. And he said the Supreme Court has allowed corrupt foreign corporations to influence our election and to spend money on our elections. And Justice Sam Alito, whom we invoked on this show last time, so hopefully he'll become a good friend of the pod, Justice Alito, drop us a comment on YouTube if you're listening. He made this face. He was like, what are you talking about?
He reacted. They're not supposed to react, right?
Right.
During the State of the Union?
Right, that's the theory.
Everyone around them is freaking out, always. Right. They've got paddles and they're screaming, and the justices are just sitting there.
Yeah, as Alito has described it, like, what, are we supposed to just be potted plants? And, so the answer is, I guess, yes. And so the camera caught him making this face of like shock and disbelief, like, President Obama, what the heck are you talking about? And ever since then, he has not shown up to a State of the Union address.
He doesn't attend them?
He doesn't attend them anymore.
That's amazing. I love that. He's like, I can't listen to that and not just have an absurd reaction, you know?
Which is kind of interesting because...
Spirit animal.
Yeah.
How different is that
spirit.
from what Justice Ketanji Brown Jackson did at the... I'm embarrassed. Is it the Grammys? What's the difference between Grammys and Emmys?
Emmys is TV.
Oh, okay. Well, anyway,
I don't... watch a lot of daytime television.
This is why you two are here to help me through
these
issues.
Grammys is
the Grammys.
music.
And it's music because Justin Bieber was up there singing in his underwear. So there you go. Music.
Really?
Really. Look it up. He actually did a pretty good job. But he was
Billie Eilish talking about Stolen Land? Grammys. Musician.
I did see something about this on X.
So it is crazy to me that Ketanji Brown could go to the Grammys and clap and applaud and stand up when people said things like what Billie Eilish did, which is that no human is illegal on stolen land. To me, that seems clearly political. If people were mad at Alito for just a facial expression, standing and clapping the things that they're not supposed to do at the State of the Union, then seems like an obvious political expression to me.
Can I give a really based opinion about this?
Always.
By all means.
That is what the show's about. I'm not committed to this view, and people are going to think I'm absolutely crazy. But they already think I'm crazy, but it doesn't mean I'm wrong, okay, to the listeners. Okay, I may be mad, but that doesn't mean I am wrong. But judges are political creatures. I mean, you know how many Supreme Court justices and judges have previously been members of Congress? I mean, Chief Justice Taft had been president of the United States. Charles Evan Hughes resigned for the Supreme Court to run for president of the United States. Hugo Black was a senator. Like, judges are political creatures. And like, what's the point of hiding that? Right? I mean, just to pretend that they're actually these neutral people without political opinions. The role of a judge should be to adjudicate cases under the law as you understand it. And you should always strive to be a neutral arbiter. So your political opinions shouldn't come into play. But what's the point of pretending that judges don't have those political opinions? So am I crazy to think that, Emil Bove, who's now in the Third Circuit and who worked for Trump and who got a lot of crap for attending a Trump event after he was confirmed, like, okay, you could go to a Trump event. Like, you were friends, you were his lawyer, like you worked in his administration. And I think Ketanji Brown Jackson should be able to go to the Grammys and laugh at political jokes, right? Is that crazy?
I like that. I think that's true. I hate the idea that we try and pretend that some things are unbiased. Certain sources will say we're totally unbiased. There's just no such thing as being completely unbiased. Now, when it comes to the Supreme Court, yeah, you can look at what they're doing and making sure they're applying the law correctly. And you can evaluate their actions in a way that maybe is totally unbiased and should be. But the way they act the rest of their life is never going to be completely unbiased. And it gets taken so far. Like, who was it that flew the flag and appealed to heaven?
Justice Alito's wife.
They were so mad about this flag. Like,
because they don't know they don't know history. Appeal to heaven. It's in John Locke, right? When the civil government becomes tyrannical and you want to rebel against the government, what legal authority do you appeal to? Heaven.
Yeah.
Natural law. That's all it is. It's like the right of revolution. Anyway, so that's an example of, like, judges should be allowed to express those opinions. And maybe, as you said, Kathryn, I agree. Like, just be open about it. We should know what your biases are, and we should see if you successfully overcome them. Instead of hiding them. But anyway, we're doing a little bit of the weave here, right? And so
the Trump weave.
So to bring it back to the Citizens United, let me just say one last thing about this, which is, if Don Lemon has the right to publish this video, which he does, that's part of the freedom of the press, then Citizens United has the right to publish a video about Hillary Clinton before an election in which she is running for president of the United States. That's literally what they said. I mean, just because you have a corporate form, you aren't allowed. Citizens United was a corporation. You aren't allowed to spend money disseminating a video documentary you did about Hillary Clinton.
Yeah, that is insane.
That's the press. That's the press. There is no difference between Citizens United in this respect and the New York Times, which is also, by the way, a corporation.
Right.
So there's no special institutional protection. So if you want to read the article about this, Michael McConnell at Stanford, a great friend of mine, has an article that I think is called In Defense of Citizens United in the Law Journal that says, so do you know who Justice Anthony Kennedy was? Okay, I maybe a little bit.
Maybe a refresher.
Yeah. So he's the one who retired, and then Brett Kavanaugh was appointed, the first appointment.
Okay.
Yeah, so a second appointment, I guess I should say. Neil Gorsuch was the first appointment of the first Trump administration. So it was a Kennedy opinion, and Kennedy liked to meander. It was like a 100-page opinion about free speech and campaign finance. And Michael McConnell, Professor McConnell at Stanford, just writes this article in the Law Journal being like, this could have been a 2-paragraph opinion, right? Is the publishing of a video on Hillary Clinton a political candidate freedom of the press?
Right.
And does the corporate form derogate from that freedom? Well, the New York Times is a corporation. Ergo, which is Latin for therefore, they have a right to publish. That's freedom of the press, right, about Hillary Clinton. So anyway, Don Lemon, you have absolutely every right to publish your video. It doesn't mean you are exempt from generally applicable and neutral laws, just like the rest of us.
Right, because that's what is at issue here, isn't it? Is whether or not Don Lemon, in producing this piece of journalism or whatever, was preventing people from worshiping in their place of worship. I mean, at a certain point, that's trespassing, I would think. But the question is, was he there reporting on the event, or was he part of the act of obstruction?
That's
I was just going to say we could test this theory. I think us as journalists could go and storm a mosque, perhaps, and just see what happens. And we'll see what people think about that. And if we keep people from practicing their religion as they have the right to, I think people would be a little bit more angry.
I'll let you test.
Yeah, I'll let you too. Okay, so Kathryn, you're it. Thank you for volunteering. Your idea, you do that. But the analogy is like it's appropriate in the sense, right? Everybody agrees that you can't just break down someone's home because they're a public figure and you have a right to report on what's going on in their home, right? I mean, there's the Ashley Biden diary, like that's like legitimate content for investigation. Doesn't mean you can steal it or whatever happened. I don't remember exactly the details of that case. But as Grace said, like there are state law claims, like trespass. I think they would certainly be prosecutable under state law. The question here, of course, is Don Lemon also guilty of violating the Federal FACE Act, which we talked about last time? And here, his being a journalist, again, doesn't exempt you from the FACE Act, but it might be relevant to his state of mind, right? It might be relevant, right? Because it's like there's intent in the statute and intent to do what. So did we read it last time? I'm not sure we read the full
I don't
act.
recall, but we can right now. So just to remind us all, FACE stands for Freedom of Access to Clinic Entrances Act, but it also includes language in there about places of religious worship. Here is the text. Whoever by force or threat of force or by physical obstruction intentionally injures, intimidates, or interferes with, or attempts to injure, intimidate, or interfere with any person lawfully exercising or seeking to exercise the First Amendment right of religious freedom at a place of worship shall be guilty of violation. That seems pretty cut and dry to me. I don't know.
He had his microphone and was shoving it in the face of a pastor who was trying to give a sermon, actively was out there to try and give a sermon. I mean, that's not legitimate journalism.
I just don't see why he couldn't have waited for the protest to end and for the pastor to leave and then interview him outside of the space of worship.
Right.
That's my sticking point in this case.
Yeah, so he'll have some potential defenses, but they might be tough, but it'll depend, of course, on the facts. The journalist question, though, goes to the state of mind, right? You read the part about intentionally, right? So it says through a physical obstruction, intentionally interferes with or attempts to interfere with. And this might be too technical. So readers, if you don't like this, or listeners, if you don't like this, drop a comment and say, don't talk about this nonsense again. But there's this concept in criminal law called specific intent crimes versus general intent crimes. So specific intent crimes are those you must actually intend the result in question. So if this were a specific intent crime, Don Lemon must have intended to interfere. That was the reason he did it. Okay. But if it's a general intent crime, he must merely intend to do the acts in question, which acts happen to interfere, even if his goal was to do something else. And so if it's a specific intent crime, he probably has a defense being like, actually, I didn't intend to interfere. I intended to come as a journalist, even though my actions happened to interfere. But it doesn't read that way to me. I actually had my research assistant look up if there are any cases interpreting this part of the statute, and there aren't any as far as we could find. But it reads like a general intent crime to me, actually. So
who decides if it's general or specific intent crime?
Well, usually the statutes have some like clues. So statutes that say if you must willfully do something, usually willful means you must actually intend the result that is accomplished. Other things is just like the law, the common law history, it just tells us that it's a specific intent crime. So if I take your phone, which is right here, but is that theft? Well, not if I don't have a Kathryn. No, the answer is no. It's not theft. Unless I have an intent to deprive you of it, permanently deprive you of it. For all you know, I was taking it because, well, I don't know. I guess I wouldn't have really a good reason to take it. So it would be, an inference against me. But you understand the point. The act of simply taking something isn't enough to make something theft. You have to have an intent to accomplish a particular result. And so we know it from the statute. We know it from sort of common law. So, but here I don't think, it reads like a general intent. Like he must merely have intended to do the acts that happen to interfere. His better defense might be the definition of physical obstruction. By the way, did he actually physically obstruct normal people? Like that looks like a physical obstruction. But as I like to tell my students, always look at the statute to see if it has like a special definition. And here it does define physical obstruction as like obstructing ingress and egress from the facility. Yeah, those are fun words.
So from people going in or out?
Yeah, that's right. And that's right. Exactly.
I should be writing these laws.
Yes. That's right. Why can't we just say going in and out, like ingress and egress? And there clearly were people who did that, and they have. I think some of them have been arrested and charged and so on. But I suppose the question is whether Don Lemon did it, which we don't know. So,
interesting.
But that's a defense, putting aside constitutional defenses, he has the possible physical obstruction defense, and he could possibly argue about sort of the specific intent. But that's kind of an uphill battle.
Well, there's one other argument that Don Lemon may have, right? If you follow us on X at RationallyPod, you'll know that some folks have said Don Lemon may have a different constitutional defense. What gives Congress the right to even enact the FACE Act? Apparently, if you look at Article 1, Section 8 of the Constitution, which enumerated Congress's power, this doesn't look like it falls under any of those powers.
Yeah, so Don Lemon, would you like to hire me to spring you out of jail? But the cost is you have to burn down the New Deal state, or all these precedents for the New Deal. So, okay, maybe you don't have to go that far, but some of us would like to go that far.
I like it.
I'm not telling
I'm
you if I'd like to go that far or not. I'm just saying some people. I mean,
Again, this is called the Rationally Based Podcast.
Speaking for a friend, some people would like to reverse the New Deal state. But
I'm the friend.
yeah. When I say speaking for a friend, it's always Kathryn. The crazier the idea is, again, doesn't mean it's wrong. Could be crazy. Doesn't mean it's wrong. So as you said, so Congress only has powers. So we discussed a little bit on our first episode. Congress, the federal government, is supreme over contrary state law, but only within its sphere, right? So it has limited and enumerated powers. Those powers are described in Article 1, Section 8 of the Constitution, which lists Congress's power. Where does Congress get all the power to regulate our everyday lives, all the economic transactions that we engage in? Where does it get the power to do this the FACE Act, either provision, right? The abortion provision, the abortion clinic provision, or the religious assembly provision? And the answer is Congress's power over interstate commerce, or Congress's power to regulate commerce among the states. Now, the listeners should be like, how is this commerce? Which I see it on your face.
The church was in one state. They're all in Minnesota. How does that make sense?
It's all within one state, so it's not among the states. And is it commerce, which is another question. So historically, Kathryn, your instincts are excellent. As a historical matter, Congress's power over interstate commerce was just the power to regulate trade across state line, barter, the exchange of goods, the sale of goods across state lines. So historically, commerce was something other than production. Agriculture, mining, refining, labor laws, all these things were preceded commerce and were called production, and they were articles of commerce. So the states continued to regulate labor, production, mining, agriculture, and the like. But over time, in the New Deal, in order to justify a lot of the New Deal federal regulations, the Supreme Court made two moves. First, it said that production is kind of sort of commerce, kind of sort of close enough. So they basically said, well, production has a direct effect on commerce, a substantial effect on commerce because it becomes commerce. So it totally collapsed this distinction. And now, today when we hear commerce, we think, oh, economics. But no, it used to be just the exchange of goods. So first it extended the doctrine to cover things that preceded commerce production, and then it also extended it to things entirely within a single state. So the famous...
Crazy.
You think that's crazy? Let me tell
we're
you.
just getting started.
Yeah, let me tell you about a case called Wickard against Filburn. And the way I like to tell my students you could remember this is Wickard versus Farmer Filburn. So
Cute.
Farmer Filburn...
Are your students kindergartners?
Oh no, but it's a heuristic to help
that's very
remember.
helpful.
Yes,
that's very helpful. Thank you.
So Farmer Filburn was growing wheat on his own farm entirely for his own purposes, at least under the assumed facts of the case.
Okay.
So he gave some feed, used some as feed for his animals, and then he used some for his own consumption, entirely within his state. Didn't sell to anybody, wasn't commerce, didn't go across state lines anyway. So again, own production on his own farm for his own purposes, entirely within a state.
Oh, he's golden.
You would think. Think again.
Just what year is this? Contextual.
I believe it's
Decade.
1946, 1947,
Okay.
but it's in the 1940s, just after World War II. And the question was, can Congress impose quotas, production quotas, saying Farmer Filburn cannot raise more than X amount of wheat as a regulation of interstate commerce? And he's like, what are you talking about? I'm not engaged in commerce. I'm not engaged in anything interstate.
Yeah.
My own farm, right? And the Supreme Court upheld Congress's power. I know Grace looks shocked.
That's off. That's enraging.
And not only is that enraging, but the reasoning is even more enraging. It basically, what is the connection to commerce, you ask, or one might ask? And the answer is, well, by growing his own wheat, he was forestalling access to the market. So by growing his own wheat, if he hadn't grown his own wheat, he could have bought it on the market. So basically, we prefer consumers, right? Like, oh, don't be a producer. We want you to buy stuff, right? And so if now again, so that reduces demand and reduces the price. And how could one person's impact on this matter? How can that really affect interstate commerce? Good question. So what the court basically said is, well, Farmer Filburn alone may not have an effect on interstate commerce, but if everybody started to grow their own wheat, the horror, then we wouldn't have an interstate wheat market. And so in the aggregate, if you aggregate the actions of individual farmers like Farmer Filburn, in the aggregate, that might have a substantial effect on interstate prices and therefore interstate commerce.
It feels like such a slippery slope.
It is I'm hardcore. I think it's just like exchange of goods, right? And so I would get rid of production sort of altogether, but certainly entirely in your own, farm. It is kind of crazy. I will say that the Supreme Court has tried to rein in a little bit the reach of the Commerce Clause in like the 1990s.
Always hard to do. It's like the growth of government. It's so difficult to shrink it back again, almost impossible.
That's exactly right. What is it? Was it Reagan? I guess we're invoking Reagan again. Before your time, just kind of I was there a little bit, in diapers still at the time. But he said there's nothing closer to eternal life than a government program.
Yes.
Right? And
just funny.
There's, the same thing with the Commerce Clause. Like it's just a constant one-way ratchet in favor of federal power. But there was some glimmer of hope in the 90s and early 2000s when Congress enacted the Gun-Free School Zones Act. In its infinite wisdom, even though there were already state laws against possessing guns in school zones, like 47 states had these laws, Congress in its infinite wisdom said, let's make it a federal crime to possess a gun near a school. Is that interstate commerce?
No.
Well, under Wickard v. Filburn, can you make the argument, under Wickard v.
What? They're not going to go buy guns?
Is it like because it impacts consumers buying guns?
It's even more clever than that. The argument would be that guns near schools affects the educational process, and education over time affects someone's productivity, and someone's productivity affects interstate commerce. This was the view of 4 liberal justices in dissent in that case.
It feels like the biggest leap of logic, like the biggest stretch.
Well, you could be a Supreme Court justice, Grace, because what the majority said was it would require piling inference upon inference to get from a gun near a school to this substantial effect on commerce. So what they basically said is, okay, that's too much. That's too much. Guns, possessing a gun isn't economic. Being near a school isn't economic. Even education, they said, isn't economic.
So that didn't stick.
That's right. They invalidated it.
Okay.
But it's still crazy that 4 justices had, obviously, as we talked about earlier, some kind of political motive, I would think, because the only thing that would, cause them to vote that way would to be thinking guns bad, and nothing else, right?
Which reminds me of how abortion, federal abortion laws made it through past the Supreme Court, based on the privacy provision.
So then why go and pretend to be this unbiased figure by not attending the Grammys or whatever? I don't know, just buy it, whatever. You're not fooling us when we look back at all these things.
Yeah, a lot of these 5-4 controversial decisions definitely look political, right? And you could say that, of course, for the conservative majority. Well, they like guns or whatever. I mean, but at least
no one likes guns in schools, really.
Fair. Well, you're right. I mean, there were 47 state laws, I think, already, or 40 something. I don't know the exact number. So, again, why did you need, other than appear to be doing something to win votes back to your constituents or something? Now, but the court held it back. The court said that much was too much, and if that's too much, maybe the FACE Act.
Okay, so can we go back to, is Don Lemon the farmer in this situation?
I know, we're doing the
We've weaved too close to the sun.
Yes, Don Lemon is Farmer Filburn. So Don, are you ready? Are you ready to take on the New Deal?
So if Congress didn't have the authority to, pass the FACE Act, then there would be no way to prosecute Don Lemon for, interfering in this worship.
They could prosecute him, but then Don Lemon, as a defense to the prosecution, should say the law under which he's being prosecuted is unconstitutional because it exceeds Congress's power under the Commerce Clause. Now,
that'd be a fun case to watch. I hope he does that.
Don, here is some free legal advice, but I am not your lawyer. This is not an attorney-client relationship, so I know it's on camera, but I will now deny having said that this is legal advice. Here is a free legal opinion from a pundit who's not your lawyer. You do have an argument that at least the religious assembly portion is unconstitutional, even under the gun-free school zones case, because is that really economic? Though, pastors are paid and people donate to the church. And surely, by the way, going to church makes citizens more productive, the rest of the week. I don't know. But you could make an argument under, that it's not economic, and therefore under the modern, the cases from the 1990s and 2000s, maybe you get off scot-free, but just to be safe, you should just argue that the whole New Deal state was wrong, that Wickard v. Filburn was wrongly decided, and if you want to hire me, I will happily make that argument for you. So Don, you have to choose, okay, your freedom or the New Deal. Okay, that's your choice, and I'm happy to provide legal services should you desire them.
I love that, Don Lemon. If you decide to do that, I will completely change my opinion on you. So that's also another reason.
As one of my law professor friends said, I didn't have Don Lemon challenging the New Deal on my bingo card for this year. But
all right, well, let's move on from the Don Lemon, and let's go into something else because there was other breaking news last week, which is really interesting. Just this past Friday, the state of Missouri filed a lawsuit arguing that it is actually unconstitutional to count illegal aliens and temporary visitors in the census. This is a big deal because if they win this, and the census does not count illegal aliens and temporary visitors, the 2030 apportionment would change in kind of drastic and interesting ways.
Right, because right now, illegal aliens are counted in the census. And what does the census impact? Civics 101. It impacts how much representation each state has in the U.S. House. We have the Senate, U.S. Senate, and the U.S. House. U.S. Senate, each state gets 2 members. U.S. House representation is based on a state's population. And so a census is not just, how many states or how many people are living in my state, little fun fact, little trivia. It has huge ramifications for the makeup of the, U.S. Congress.
But also presidential elections, right?
Also
because
that.
It's the amount of delegates you get to go to the presidential election.
That's right. Yeah, the Electoral College.
Yeah.
There's some data out
Presidential
there.
election, Electoral College, same thing. Yeah.
Schoolhouse Rock, just flash me.
Oh, we should do an episode on that. Listeners, drop a comment. Would you like us to defend the Electoral College? Because I will defend it. I will defend it.
I like it. Although this is crazy. I mean, when did we even start counting illegal aliens in the census? I think there's a lot of people out there that don't even know we do this.
Absolutely.
So according to the lawsuit that was filed by the state of Missouri, by the way, you may have heard it first on Rationally Based. If you follow us on X, we may have been the very first to report it because I was my friend is the Solicitor General of the state of Missouri, and I was talking with him. He's like, "Oh yeah, we just filed," and I'm like, "Oh, I'm gonna tweet." He said, "Oh yeah, Fox News is going to run a story." But no, it's not. Rationally Based is going to break that story. So
breaking
we did.
news at Rationally Pod.
So follow us, Rationally Based Podcaster at Rationally Pod. But according to the lawsuit, apparently it was the Carter administration that made the conscientious decision to expressly include and encourage the counting of unlawfully present aliens and I don't know if in 1980, I can't remember from the lawsuit, that's also when they decided to count like student visas. That might have been before. That's not to say they didn't count them before. There was no explicit policy one way or another. And presumably, if you're here illegally, like you don't answer the door when the census man comes by and say, "Who are you?" But there was an active encouragement to do it in 1980. And they say that was sort of like the first time that we expressly counted them. But you're right. If you count them, there are great apportionment ramifications. And the complaint actually has some maps about this showing how different like the 2020 and I think 2030
Yeah, these maps are super interesting. So let's put the first one on the screen. You can now watch on Spotify as well. So if you're on Spotify, click open your app and you'll be able to see the map in front of us. This first one is if the 2020 census and 2021 apportionment had included only citizens and lawful permanent residents as the Constitution requires, this is how it would be different in our last election.
So what are we looking at here?
Most notably to me, California loses 3, which seems huge.
Yeah, New York loses 1, so that's 4, I guess, blue states in that election. Texas loses 1, though, 2.
Right.
So maybe that offsets New York. And the rest look like a bunch of swing states, actually, which is interesting.
They do, and they all gain
But Trump, no, in 2020... no, this is the 2024 election. How would that have been different? Yeah, in 2024. So this is the 2020 apportionment, how that would have been different. And under the 2024 election, Trump did win all the swing states. So I think I saw it was like 9. Someone said that he would have won by 9 additional electoral votes.
That
would have changed the outcome, but he would have won by a wider margin.
By more.
We've got Michigan and Pennsylvania that gained notably. So yeah, that makes sense.
Ohio.
And so they also talk about how the 2030 census will change. So if our wonderful producer Isaac has that map in front of him.
Yeah, let's switch over to that one.
Now, this map is harder to read because it's actually the delta, the change in what the apportionment would be from the anticipated apportionment based on the anticipated 2030.
We don't have these numbers yet.
So Minnesota isn't going to get. So Minnesota's up here, which is interesting.
Yeah.
And Minnesota, it says 1, so we gain 1, but that doesn't mean we're going to have 9. It's because it means we would stay at 8. because we're anticipated to lose one. So we're anticipated to have 7, and here we'll gain 1. But here it's all over the map. It's not just swing states, right? I mean, California.
You've got California losing 3, Texas losing 2, New York losing 1.
Illinois.
And
look, there's a bunch of those small states. Okay, how good are you at geography? Are we ready?
Are
we ready?
That's Massachusetts. I know
the 50
that.
states.
New Jersey.
So yeah, in Massachusetts, New Jersey. I think that's Maryland.
That's Maryland. Yep.
And then there's like a 1. So is that?
Ooh.
Is
Someone's
Delaware?
gaining 1.
Is that Delaware?
Delaware
gaining one?
right. Correct us if we're wrong. Isaac's nodding.
Okay, good. Our producer is better at geography than we are. Florida, Missouri, Tennessee, Ohio, Oklahoma. I'm pretty good at the geography. For the record, can I get some
Again,
credit?
Schoolhouse Rock.
South Carolina. No, North Carolina. That went for Trump, right? That's is North Carolina?
Yeah,
that used to be a swing state? In my youth, when Florida was a swing state, is North Carolina still a swing state?
I think it's kind of on the edge, but I think it's still sort of a swing state.
Now, Virginia was red, I think, when I was growing up, but now, so they're going to gain 1. And so anyway, we haven't done the math. If there's someone good at math who can figure out, based on the anticipated 2030 census, plus the delta from here, how much would Trump have won under the 2024 map? Because obviously, that's probably why they want to do this lawsuit, aside from the constitutional merits, which we'll talk about, but clearly beneficial to Republicans, I think.
I think, at least in as far as the presidential race goes, when it comes to congressional representation, Minnesota, if we lost or gained 1, it could really be red or blue, depending on how they were to split it up, because we have so many, such a high population density in those blue areas. So I don't know. But when it comes to presidential votes, we are solidly going blue, so it certainly affects that. But they also included in the lawsuit some interesting things. They said including illegal aliens in the census has unlawfully inflated the representation of states like California and New York. For example, in Los Angeles alone, there are about 2 million illegal aliens that make up about 10% of the city's population.
Oh my gosh.
For
10%.
reference,
that is unreal.
The number of illegal aliens in Los Angeles is roughly equivalent to 1/3 of Missouri's population of 6.15 million people.
Holy cow.
Isn't that crazy?
So I guess the reason Missouri is filing this lawsuit is because if you look at these maps, they would have standing, presumably, because they actually stand to gain something.
Yeah.
So that's interesting. Those numbers are pretty astonishing.
Okay, so walk us through it, law professor. How does this
why we're here.
work? How does it actually relate to apportionment?
Okay, so does this lawsuit have any legs? So the census, the enumeration of the people, and the apportionment actually work together in the Constitution. Now, in the original Constitution, the apportionment clause, was also known as the 3/5 clause, which is something that we can talk about because of the enslaved population and how they were counted. So let's read it, because this is critical. The way it's structured is critical. So a lot of people think that this lawsuit doesn't actually have any legs because it says, you count the whole number of persons. But that's not actually what it says. So it says, representatives and direct taxes. By the way, what are direct taxes? We can have a whole episode about that. Nobody knows.
Nobody knows?
Well, okay. It's at least like a land tax. We know that that's direct tax and a per person tax. But okay, sorry, I'm getting too distracted, as my students would say, which is why I never finish class on time. Representatives and direct taxes shall be apportioned among the several states, which may be included within this union, according to their respective numbers. That's the injunction. I'm going to read it again. Representatives and direct taxes shall be apportioned among the several states which may be included within this union according to their respective numbers, which shall be determined by adding to the whole number of free persons and excluding Indians not taxed, 3/5 of all other persons. Now, this has been amended to get rid of the 3/5 clause, which someday we'll have an episode on the 3/5 clause and slavery, and we can talk a little bit about that. The 14th Amendment's apportionment clause just gets rid of that, right, after the abolition of slavery. So the question here is, do you, for the census, actually have to count all persons, like the whole number of all persons, or only the whole number of free persons who count as being among a state's numbers? Now, what is a state's numbers? Well, Missouri argues, to be counted as among the numbers of a state, like their numbers, their respective numbers, you must be a member of the political community, which does not include transient visitors, and it does not include, they say, unlawfully present aliens, illegal aliens, because they can be removed at any time. They say lawfully establish a domicile. So to draw an analogy, it's like if the census had said, representatives shall be apportioned among the states according to their respective French population, counting the whole number of persons and 3/5 of other persons. You wouldn't count literally all persons. You would count whole number of persons who are also French, and 3/5 of other French persons who would presumably under this preposterous hypothetical be enslaved. And so again, the question is, who are the respective numbers of estates? When it says their respective numbers, does that include people there on a tourist visa? Actually, no, we even don't count that. So if we don't count people on a tourist visa, even though they are persons,
Right.
they're on
Residing in the
census
state
day.
at the time.
So whole number of persons.
So it seems like maybe it comes down to this term respective numbers. Is that something they used in that time and had a definition for in that time that we don't right now? No?
So what the lawsuit says is that we do have the statutes creating the census and authorizing the census for the first several decades. And it says counting inhabitants. Who are the inhabitants of a state? Well, it's the people who live there and have a domicile there. So it wouldn't include temporary visitors, and arguably would not include people who are here illegally, who could be removed at any time, and therefore cannot legally, the lawsuit argues, establish a domicile. So you have to be an inhabitant. One other point, by the way, a whole number of persons, why would they specify that? In addition to just clarifying how the enslaved population would be counted, that 3/5 versus whole. It's like, do women and children count? Right, for purposes of apportionment. So, because when you say a state's respective numbers, like, is that under representational theory? Right, this is who is entitled to representation in a Republican form of government. Is it just males? Is it just voting males? Or are women and children entitled to representation, even if at the time they could not vote? And so that's why you have to say whole number of persons to also specify that, like, women and children count for purposes of the census.
So that's that means.
And apportionment. Yeah.
Okay.
That is so interesting.
So the verdict is the census litigation may actually have some legs, contrary to all the punditry and scholars that you hear online. The Missouri litigation has a fighting chance.
So we are bumping up against our time, but could you just quickly give us a little preview of the 3/5 compromise ranks? I am very curious to talk more about this issue in the future, but in a nutshell.
Yeah, so I always get in trouble when I talk about this in class because somebody inevitably misunderstands what I'm saying.
That seems, I can see how that would happen.
So I like
subject.
to say the 3/5 clause is actually bad, but not for the reason everybody thinks. It's not because they thought that, like, African Americans or enslaved African Americans were somehow subhuman or only worth 3/5 of a person. On the contrary, the South wanted the enslaved population to count as 5/5 of a person. Why? Because it gave them more power in the Electoral College. It gave them more representation in the House.
Which would then incentivize them to perpetuate slavery and import more slaves.
Exactly. So it's the Northerners who didn't want to count the enslaved population at all. It's the North, the abolitionists, who wanted them to count as 0/5 for purposes of representation. So this was called the slavery bonus, the 3/5 bonus, which explains why so many Virginians were our first president. Did you know that John Adams almost certainly would have won re-election in the election of 1800 if the 3/5 bonus had not been there, if slaves did not count for apportionment and electoral college? John Adams would have won, and the Jeffersonian Revolution, the Revolution of 1800, none of that would have happened. The era of good feelings, War of 1812 may not have happened. Can you imagine how history might have been different? But okay, slavery and the Constitution. Stay tuned for the celebrations on this rationally based podcast about the semi-quincentennial of American independence. We really have to decide if we're calling it that. Semi-quincentennial,
I can't
America
say it,
250.
so maybe.
Well, I know that's why I'm going to keep saying it, because I find that amusing. But
I did want to
nice
point
of
out
you.
one other thing that this lawsuit mentions, which is that really counting the census in this way, counting people in this way for the purposes of the census, incentivizes states to disobey the federal government and bring in more illegal immigrants to their state. I mean, it's obvious, right? And we've seen it in Minnesota, where we have laws now where if you are an illegal immigrant in Minnesota, you can get your college paid for, you can get free health care, you can get a driver's license. And all of these programs are meant to incentivize illegal aliens here in Minnesota. So hopefully that would cause some sort of growth of the power of Minnesota. I think that's just obviously true, but they mention it in this lawsuit, and so I think it's worth pointing out.
Yeah, it feels very exploitative, too, to be encouraging people to enter a country illegally with the knowledge that they could later be deported and have their lives uprooted,
Right.
which is happening right now with all of ICE's activities, solely so that your state can have more representation. It feels wrong to me.
And people bring up this a lot as kind of a conspiracy theory or something like that, or the idea that, you know, there's a party that is incentivizing illegal immigrants and wants legal immigrants to be here for political power.
To use them
For political power and their own gain. People talk about that as a conspiracy theory. It's not at all. It's really, I think, what's going on, and it's what this lawsuit claims as well.
Well, it's a lawsuit to watch. So we are up on our hour. What is on deck for next time?
Well, we keep promising you guys to talk about birthright citizenship.
Oh, and like and comment and tell us. Don't forget, like, you know, I'm not the one who's supposed to be remembering this. Like, comment, tell us what you want us to talk about.
Yeah, absolutely. We really value your guys' feedback. Please continue to talk to us through X or Instagram or YouTube or Spotify, anywhere you're listening. We want to hear from you guys. We want to know what you want to talk about. We did do a poll on X. Again, that's @RationallyPod. And people really do want to hear about birthright citizenship. So we promise we're going to get to it very soon, hopefully next week. But breaking news just kind of keeps getting in the way of us. Yeah. But fingers crossed, that will be coming next week.
Well, thank you for joining us on the Rationally Based Podcast.